This is Bloomberg Law with June Grasso from Bloomberg Radio.
Former Alaska Governor Sarah Palin became well known back in 2008 as the late John McCain's vice presidential running mate. She also became well known for a series of verbal slips, gaffes, and generally cringeworthy moments.
They're our next-door neighbors, and you can actually see Russia from land here in Alaska.
Obviously, got to stand with our North Korean allies. We're bound to by treaty. We're also bound by, yeah.
I told Congress, thanks, but no thanks for that bridge to nowhere up in Alaska.
Since then, Palin's star has gradually faded, although the spotlight returned in 2017 when she sued the New York Times for defamation. But this week, for the second time, a Manhattan jury found that the Times did not defame Palin. Joining me is an expert in First Amendment law, Samantha Barbas, a professor of law at the University of Iowa College of Law. Tell us why Palin sued the Times.
So this story goes back to 2011 when there was a tragic shooting of Representative Gabby Giffords in Arizona. And 6 years later, there was another tragic shooting at a baseball game in which various Republican politicians were participating, and a congressman was hit. And the day after that, the New York Times ran an editorial in which it suggested that there was a link between kind of violent political environment that various people were promoting and these tragic mass shootings. In particular, it pointed to a digital graphic that had been produced by Sarah Palin's Political Action Committee, I think back in 2011, around the time of the Arizona shooting. And that graphic used crosshairs to target various congressional districts that I guess Palin was interested in focusing on, interested in having her campaign focus on these Democratic political districts. But the New York Times suggested that that was actually kind of an incitement to violence, the use of crosshairs and kind of, inciting people to take vicious action against their political enemies. And so the Times effectively linked that graphic to the shooting of Gabby Giffords in Arizona. And Sarah Palin said that this was false, that her Political Action Committee had nothing to do with the shooting, and that her reputation was injured, that she was defamed. And that's the origin of her libel claim against the New York Times.
This legal fight has been going on for 8 years now, and this is the second time that a jury has heard the case and ruled against her. What happened the first time?
So the first time, this was in 2022, and importantly, the standard here is actual malice. So because Sarah Palin is a public figure, she had to show that the false statement was made with reckless disregard of the truth, so that the Times either knew the statement was false and published it anyway, or had really strong reason to believe that the statement was untrue. And, during the trial, the evidence was presented about what the Times opinion page editor knew and did not know when this editorial was issued. And the Judge Rakoff, at the close of the trial, suggested that even if the jury found for Sarah Palin, he would set aside the decision. And while the jury was deliberating, apparently they were notified of Judge Rakoff's pronouncement that he would set aside the verdict. And some of them even got push notifications on their phones about this. They obviously found in favor of the Times, and Sarah Palin appealed, suggesting that these procedural irregularities merited a new trial. And that's why we had the trial that concluded a couple of days ago.
The person in charge of the Times opinion section admitted he'd made a mistake, said he acted quickly to rectify it. So was the main question for the jury whether he acted with reckless disregard for the truth?
Yeah. So, again, the issue was, what did the Times editor know at the time he made the decision to publish this editorial? Did he know that these statements were false, connecting Palin to the shooting? Did he have strong reason to believe that the statements were false and nevertheless allow them to be issued? And so it's the Times argument that, we were careless, right? We made a mistake. We apologized. Our journalism was sloppy here, but we attempted to correct that as quickly as possible. And what we did didn't rise to the level of reckless disregard of the truth. It was merely negligence. And that's not sufficient in a libel case involving a public figure.
So did Palin's testimony relate at all to that question, or was it just about damages?
So Palin's testimony was about the harm that she alleged that she'd suffered. She said things like, it kicked the oomph out of you, I guess is the language she used, right, to describe how injurious these statements were to her sense of self, her emotional state. But interestingly, I don't think she was able to demonstrate that she'd actually suffered reputational harm. I don't think she lost any speaking engagements or book deals or anything tangible as a result of this allegation. But yes, her testimony was mainly on the harm that she had suffered.
So what do you think the message is after a second jury, basically with the same set of facts, comes to the conclusion that the Times didn't defame her?
Yeah, well, I think the conclusion is that actual malice is a very high bar to clear, and that it does a good job of protecting the press in situations where there may be an honest mistake, a mistake that a responsible news publication goes out of its way to attempt to correct. And, actual malice says that that's not punishable. So now there's the question of whether or not Palin will attempt to appeal this and whether this win for the Times will sort of fuel the momentum that's out there to get the Supreme Court to reconsider the actual malice standard. That's kind of lurking in the background of this.
I think Palin's lawyers said that they wanted to use this to attack the precedent, the landmark New York Times v. Sullivan case. Explain how that case has come under fire recently.
So the attack on New York Times versus Sullivan really started in earnest, I think, back in 2016 when Trump announced that he wanted to open up libel laws to make it easier for him and his allies to sue the press for libel. And I think what he was referring to was getting the Supreme Court to overrule New York Times versus Sullivan. So ever since then, there have been a number of conservative lawyers and activist groups and pundits who have been making this case, arguing that Sullivan is outdated, that it doesn't protect reputation enough, that it protects, the lying press, and that it needs to go. And these pundits and lawyers have been focusing in particular on some cases decided by the Supreme Court after Sullivan in 1967, when it extended the Sullivan actual malice standard to public figures. So Sullivan dealt only with public officials. And so the extension, sometimes called the progeny of Sullivan, really create a broad protection for the press against libel suits. But that has really been a target of these opponents. They want the court to get rid of that public figure standard or to limit the definition of who is a public figure. And, we may see that having increasing traction in the coming years.
You've written a best-selling book on the subject called Actual Malice. Do you think that the standard is too high or unfair?
No, I think that the New York Times versus Sullivan standard and the extension to public figures really strikes an appropriate balance between the protection of reputation and protections for freedom of speech and press. It is possible to recover for injury to reputation under our constitutional regime, right? If you can show this reckless disregard of the truth, you will be able to prevail. So it's not that libel law is dead, as some have said. It's just very difficult to meet the standard, and that's because we need to have a press that is free and robust, as the court said in Sullivan, press that can make an honest mistake in the course of gathering the news when, procedures may be time pressured. So I think, we have a system that's worked very well for the past 60 years that has really allowed a lot of important journalism to flourish, but still allows defamed people to recover when they can meet that standard.
I mean, I'm not sure how many people really followed this case. It did get a lot of publicity. Do you think the loss here encourages the movement to get rid of the New York Times v. Sullivan standard? What's the impact of a loss in a case like this?
Yeah, so I think they could point to this and say, there was clearly wrongdoing on the part of the Times. The Times admitted its mistake. Nevertheless, under our current constitutional regime, the plaintiff, Palin, could not recover, and they would say that's unfair, and that we need to kind of lower the bar to make it easier for public figures to recover when news media have been careless. So I can see this sort of playing into that campaign that argues actual malice is just too stringent a standard. It doesn't permit people who have been injured to get the compensation that they feel they deserve.
The press has been under attack lately, the media, especially, since Donald Trump has returned to office. Is it a surprise in any respect that the jury came back with this verdict for the New York Times, or is it not because we're talking about a jury in Manhattan?
Yeah, I think it was a little bit of a surprise. I mean, again, we have this trial taking place against a cultural and political backdrop that has not been very favorable to the press. The press is increasingly accused of not being objective, trustworthiness is questioned, and so I would not have been surprised to have seen a jury go for Palin. I think today, in libel cases, even when there's weak evidence of actual malice, the jury might be motivated to see reckless disregard of the truth just because of this distrust of the press that's so pervasive.
Any final thoughts?
I think that this could add to the momentum to overrule New York Times versus Sullivan in the progeny cases. And so I think those of us who are concerned with press freedoms are going to be watching this closely to see what happens.
Thanks so much for joining me on the show today, Samantha. That's Professor Samantha Barbas of the University of Iowa College of Law. President Donald Trump's campaign to pressure elite universities into making a wide range of policy changes consistent with the administration's agenda met its first major resistance this week when Harvard University sued the government for freezing billions of dollars in federal funding. America's oldest and richest university rejected the administration's broad demands to overhaul governance, discipline, hiring, and admissions policies that are inconsistent with the Trump agenda. The administration has framed its efforts as an initiative to fight campus anti-Semitism. Harvard's president, Alan Garber, said, "No government, regardless of which party is in power, should dictate what private universities can teach, whom they can admit and hire, and which areas of study and inquiry they can pursue." Joining me is Bloomberg legal reporter David Voreacos. Tell us about the demands that the Trump administration made on Harvard in that, I think, 5-page letter.
The Trump administration wanted Harvard to overhaul its governance, discipline, and hiring policies, as well as end its diversity, equity, and inclusion programs. And Harvard rejected that.
I mean, some of the demands were like auditing professors for plagiarism, appointing an outside overseer to make sure that academic departments were viewpoint diverse, federal government oversight of things like admissions. I mean, they were very extensive demands on Harvard that really would intrude on the way it runs its university, and many had nothing to do with anti-Semitism.
Well, Harvard says that it would intrude on the way it runs its university, and there were demands that had to do with anti-Semitism. But this moment is one in which the Trump administration is pushing for a number of other changes at the university relating to hiring, discipline, governance. And so they're taking the controversy over anti-Semitism and trying to push Harvard and other universities to make much more sweeping changes than merely beefing up its efforts to protect Jewish students against anti-Semitism.
the funding cuts go basically to medical research. It's not about what's happening at the university itself. It's about funding cuts to things like research on childhood cancer, multiple sclerosis, Parkinson's disease, Alzheimer's.
At the moment, they're funding freezes, and the freeze would also impact the education of thousands of graduate students and postdoctorate fellows in science, technology, medicine, and public health, according to the Harvard lawsuit that's in federal court in Boston.
And the lawsuit says that the government can't identify any rational connection between anti-Semitism concerns and the medical, scientific, technological, and other research it has frozen. What's the administration's response to that?
The Trump administration would essentially say that I guess the entire university and its hospitals and research divisions are infected by this anti-Semitism and DEI push at the university. Under the law, the Civil Rights Act of 1964, Title VI, says that an institution cannot discriminate based on race, color, or national origin. And Harvard says that the only way the government can punish a university under that law is to withhold funds in the specific program or area of the school that's affected by whatever the discrimination is. So that if there's, say, a department where there is anti-Semitism, it would be funding for that department or some area of research, say, that's affected by anti-Semitism. That should be the area that should be punished, not the entire university.
And Harvard is also claiming that the funding can be withheld only after there's proper procedure. The administration has to tell the school exactly what it's doing that violates the Civil Rights Act, and there has to be an opportunity for the school to respond, and there's been none of that here.
Right. Harvard says that they have to have a chance to correct whatever their failures are, and they did not get that chance. I would say that the administration has said that its demands were part of a negotiation process, but Harvard didn't see it that way. They saw it as a much more extreme measure. And so now that they've filed a lawsuit in federal court, it doesn't necessarily mean that any negotiations will stop. Civil lawsuits often end through negotiated settlements.
There's also a First Amendment claim in the lawsuit. Tell us about that.
Well, Harvard is a private institution, and it is arguing that the government cannot dictate what the mix of speech and ideology is at the university, that as a university, it tries to promote a diverse array of viewpoints and ideologies among its faculty and students and programs, and that right to do so is protected by the First Amendment on free speech grounds, and that the government cannot dictate to a private university what the proper mix of speech and ideology must be.
The administration is reportedly planning to freeze another $1 billion in research funding, and it's weighing revoking Harvard's tax-exempt status.
Right. These are all threats that have been published or floated, and they have not happened yet, but these are concerns that Harvard has raised in its lawsuit, and presumably by taking it into court, it can block future actions in the near term, at least, by the administration until the case is resolved.
Has Harvard taken steps to address anti-Semitism on campus?
Harvard has taken a number of steps. It's disciplined faculty and students. It has a task force on anti-Semitism that's done work and is about to produce a report. And it has tried to change the tone on campus from the initial days and weeks after the October 2023 attack by Hamas on Israel and the protests on campus and nationwide over Israel's response in Gaza is what led to many Jewish students saying that they were targeted by anti-Semitic behavior.
So now let's talk about the legal team that Harvard has hired. 2 conservative lawyers with connections to the Trump administration.
One of them is Bill Burke of Quinn Emanuel, and he is a conservative lawyer who actually works as the outside ethics advisor for the Trump Organization for the president's private business. And he's also represented a number of billionaires and conservative causes in his career. He is said to have a very engaging manner and formidable courtroom skills and is in some ways ideologically aligned with Trump. He's represented, for instance, Ken Griffin in his lawsuit against the IRS. Griffin's tax returns were stolen by an IRS contractor and leaked to the media. He helped to extract an apology from the IRS, and he represented a number of Trump insiders in the Mueller investigation in the first term. His co-counsel in this case is Robert Hur, who is also a conservative lawyer of King and Spalding, and he investigated Joe Biden's handling of classified documents. His report was notable because he described Biden as a well-meaning elderly man with a poor memory.
During the congressional testimony of Hur, Burke represented her, so I think that's interesting. But just today, President Trump on Truth Social said, Harvard is a threat to democracy with a lawyer who represents me and who should therefore be forced to resign immediately or be fired. He's not that good anyway, and I hope that my very big and beautiful company, now run by my sons, gets rid of him ASAP. And just like that, ASAP, the Trump Organization fired Burke. Eric Trump said in an email statement to Bloomberg News, I view it as conflict, and I will be moving in a different direction. Burke declined to comment. Let's turn now to someone Trump can't fire. The judge in the case, federal judge Allison Burroughs, who was a prosecutor and a private lawyer before becoming a judge, and who has been involved in a lot of high-profile cases, including some that involve Harvard.
Right. She handled the affirmative action case a few years ago in which she upheld Harvard's position but was later overturned by the Supreme Court, which ruled that race could not be a factor in admissions. She also recently blocked the Trump administration from capping overhead and administrative costs for government-funded research at 9 universities, including Princeton and MIT.
This attack on Harvard is part of the Trump administration's attack on elite universities. Why an attack on elite universities? What does Trump have against them? He went to the University of Pennsylvania.
I can't get into the mind of the president. I know that he believes that there's groupthink at these universities, that they have a liberal bias that is unfair to him and his supporters and the worldview that he espouses. And I believe that he thinks they've placed too much emphasis on diversity, equity, and inclusion programs, and that has made them weaker as institutions. He also is very strongly supportive of Israel and believes that there have been far too many anti-Semitic attacks and protests on campuses since October 2023.
Trump has already canceled $400 million in federal money to Columbia and issued freezes on funding at Columbia, Cornell, Northwestern, Princeton, and the University of Pennsylvania. But Harvard is the only one that has fought back and filed suit. Columbia caved.
That makes the Harvard lawsuit a significant milestone in this attack on higher education. Until this moment, when Harvard sued, universities were trying to essentially cut deals on their own, which is what many of the biggest law firms did as well. There have been several law firms that have sued. And the common thread is that they believe they have free speech rights that they're defending, and it allows them to express themselves through their business activities or their educational activities as they see fit, and that the government cannot intrude on that. Against that, Trump is threatening the loss of federal business or contracts or funding, and he brings a great deal of political firepower to this fight that these institutions, the universities and the law firms, are acutely aware of and have to navigate at this moment.
And Harvard is asking the judge to expedite its lawsuit through summary judgment. So we'll see where that goes. Thanks, David. That's Bloomberg legal reporter David Voreacos. This is Bloomberg. President Trump has been turning to the Supreme Court over and over again as lower court judges rein in his efforts to push the limits of executive power, asking the court to intervene immediately on an emergency basis to overrule lower court judges. And again today, for the 10th time in the 3 months since he took office, the Trump administration is asking the Supreme Court to block a federal judge's ruling that put the new ban on transgender service members on hold while the legal challenge by a group of service members proceeds. 10 times so far. That's more than the total number of such emergency requests during the 16 years of the presidencies of Barack Obama and George W. Bush. And it puts a new test of LGBTQ rights and presidential power before the justices. The Supreme Court allowed Trump's transgender military ban during his first term in office, but the new policy goes further. It would mean the expulsion of potentially thousands of members of the armed forces, including people who have served openly for years. Joining me is Bloomberg Supreme Court reporter Greg Stohr. Greg, tell us about the latest emergency request by the Trump administration.
The administration is asking the Supreme Court to let it ban transgender service members. The president issued the executive order on January 27th saying all transgender service members, with very few exceptions, have to leave the military, and we're not going to allow other people to enlist. A lower court blocked that, and the administration is asking the Supreme Court to lift that hold.
Yeah, so the lower court judge said that the government's arguments are not persuasive, and it's not an especially close question. And there are 2 cases involving the transgender military ban making their way through the system. One where the Ninth Circuit refused to hear the appeal, and another one where the D.C. Circuit heard arguments.
So what's at the Supreme Court right now is just one case out of a federal judge in Tacoma, Washington, where the judge blocked the policy nationwide. The Ninth Circuit refused to intervene there. There's also a second case that is currently at the Federal Appeals Court here in Washington. Similar issues, but at the moment there's not a nationwide injunction there.
I mean, usually the Supreme Court, likes the lower courts to look at things before they take it.
Yeah, and we'll see. The Supreme Court could well wait for the D.C. Circuit, the Federal Appeals Court here in Washington, to act before doing anything. On the other hand, this is a topic that the court is familiar with, at least most of the members, because the Trump administration, the first time around, had a policy that didn't go quite as far, but the Supreme Court let the Trump administration ban transgender people from serving back the first time around. The difference is, well, there are a couple differences. One, this would actually force people who are openly transgender to leave the military. And secondly, there's been an awful lot of experience with transgender people in the military. And one of the arguments in this case is that the administration didn't even look at what the experience was and whether or not those folks were serving successfully.
During the first administration, when it allowed the ban to go forward, was that just on a temporary basis as the cases made their way through the courts?
It was, but that ultimately ended up going into effect more permanently, or at least throughout the rest of that first Trump administration before President Joe Biden came into office and reversed it.
The Supreme Court asked the challengers to file a response by May 1st. What does that mean? Does that mean the court's going to consider it, is going to take it, or nothing at all?
Nothing at all. That's a pretty standard step, and it was actually Justice Elena Kagan, who's the justice who's assigned to handle matters out of the Ninth Circuit. That was her asking for it, and that's a pretty standard step whenever you get an emergency application like this. And a week is kind of a standard period of time if there's no compelling reasons to do it more quickly than that. Doesn't mean they're going to take it. In fact, the Trump administration hasn't asked them to take the case, hasn't asked them to grant cert, to use legalese there. The only thing the administration is asking for is let us go ahead and start implementing this ban while the litigation goes forward. Now, I say just, that could mean that people are actually expelled from the military during the course of the litigation.
So this is the 10th time the Trump administration has filed an emergency application with the Supreme Court. I'm sure no other administration has filed so many emergency applications at the beginning of an administration. I mean, under President Biden, the government sought emergency relief 19 times in 4 years. So, Greg, in how many of these cases has the Supreme Court granted the Trump application?
In roughly half, but in some cases the court has sort of split the difference or given a little bit to each side. So, for example, there was the case where they lifted the nationwide order that had blocked deportations under the Alien Enemies Act. But in that same decision, the court also said, but hey, people are entitled to an opportunity to appear before a judge before they are deported under the Alien Enemies Act. There's another one where they're going to hear arguments. It's still at the emergency stage, but the birthright citizenship case, they're going to hear arguments there. And then there's still another one that is as we speak, pending, involving whether the president can fire the heads of independent federal agencies.
So speaking of the birthright citizenship, where they set a special argument session in May, why do you think they did that? I think it's narrowed to nationwide injunctions. I mean, what's the emergency there?
I'm going to be speculating here because we don't know for sure. All we know is that they agreed to hear arguments. That said, this issue that you alluded to involving nationwide injunctions is something that the justices have been clear they're really interested in. Members of both parties have complained about nationwide injunctions, mostly, at least certainly these days, Republicans. And the argument is that a single judge shouldn't have the authority to block a policy nationwide, and that judge should limit whatever he or she does to the parties before them in that case. And it's an issue that the court, at least on the face of it, just wanted to think about a little bit more. Now, in the context of birthright citizenship, this is a case where the president has announced a policy to limit birthright citizenship to people who are born of either a citizen or somebody who has a green card. And that would be a massive change in the way the Constitution's 14th Amendment has been understood for the last 100-plus years. And if the court were to use this issue of nationwide injunctions to say, oh, the judges who blocked that new Trump policy can only do so for the people in front of them, that would have a tremendous practical effect, because it would mean that the president could implement that policy restricting birthright citizenship in most or depending on how exactly the court does it, maybe just half, but a big part of the country. And that would obviously be a very huge decision from a practical standpoint, even if technically it's only about that issue of nationwide injunctions.
Those should be interesting arguments in mid-May. Thanks so much, Greg. That's Bloomberg Supreme Court reporter Greg Stohr. In other legal news today, grieving relatives and survivors of a mass shooting at a July 4th parade in 2022 in Highland Park, Illinois, recounted harrowing details for hours in a packed courtroom this week, telling a judge that the attack has done long-lasting damage, while the man who admitted to carefully planning the shooting remained out of sight in his jail cell. The long-awaited sentencing hearing for Robert Crimo III brought together dozens of people whose lives were torn apart by the shooting in the Lake Michigan suburb north of Chicago. even as they were accustomed to Grimo's erratic behavior, skipping hearings, backing out of a deal with prosecutors, changing his plea, and firing attorneys. Survivors said his absence set off a range of emotions, including relief, anger, and closure. Here's Liz Turnipspeed, who was seriously injured in the shooting and now has to rely on a cane.
I don't have to think about him anymore. I don't have to worry about him anymore. And me and my husband and my daughter can continue to move forward, and I can continue to heal.
Judge Victoria Rossetti gave Crimo 7 sentences of life in prison, 1 for each of the people he killed, and 50 years in prison for each of the people he injured. There's no possibility of parole.
I was able to hear Judge Rossetti sentence him, I'm not going to use his name, to 50 years for my attempted murder. And while I don't have closure, it's closing a chapter on this part of our lives.
The judge said that there are no words that could adequately describe and capture the horror and pain that was inflicted on that July 4th. She added that Crimo is, quote, irretrievably depraved, permanently incorrigible, irreparably corrupt, and beyond any rehabilitation. Prosecutors say Crimo didn't show any regret. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.